Hello, I'm Mike Matray, and I'm the host of Healthcare Matters, where the legal and medical fields come together to discuss healthcare matters. Today's guest is Tad Devlin. He is a partner at KAUFMAN, DOLOWICH, VOLUCK. Welcome to Healthcare Matters.
Thanks, Mike. Pleasure to be here with you.
A recent RAND Corp American Medical Society study called for a complete design overhaul of electronic medical records to improve their usability. If you had the opportunity to advise an EMR vendor, how would you recommend that they redesign the products? What changes would most benefit the defensibility of a malpractice claim?
I wish that they talked with the lawyers on the front end rather than on the back end. And we've done that in the past, where we give nationwide training how to ensure accuracy and privacy, timely reporting, and security. I think some of the important flashpoints for practitioners and treaters to keep in mind are log on and log off periods, ensuring that you have a proper electronic chain of custody, that folks take the time to accurately write down into the data entry system what they intend to say. A lot of times, I have found in my personal life and in professional experience, it's much easier to use shorthand and abbreviations with texting or typing with a keyboard, if you will, or even dictation, than it were to be in the old days, if you will, when you actually get out a piece of paper and a pen, and you may take multiple drafts on a letter or a correspondence or a medical entry, and there's something more connected between your brain and your hand, I have found, and in dealing with claims, than there is behind, say, a brain and a keyboard. So I think it's important to review what you've written to make sure that you have a double submission entry point. So it's like another confirmation. Say you draft up your note, you click submit, you get an opportunity to review it. You've got a box that says, did you review and do you agree to the accuracy and certainty? And then you confirm it. So there are additional safeguards before a log entry gets made. The reason I say that is because oftentimes it's the one vague or ambiguous entry that didn't necessarily capture what the doctor meant, that the opposing side will seize upon to try to create liability or uncertainty where none exists. And it's much easier for that to be contained by an accurate record as opposed to a speaking doctor who is in a deposition or in a regulatory setting or even a trial saying, well, that's not exactly what I meant. What I meant was there's an adage in the law that witnesses talk, documents walk. And so like the picture can be 1,000 words. Those medical records and those medical file entry points are oftentimes held up before a fact finder who's called to interpret them, and an explanation from a doctor may not move the needle, no pun intended.
Well, thank you, Tad, for joining us on Healthcare Matters, where the medical and legal communities come together to discuss healthcare matters. I hope to talk to you again soon.
Great. Thanks a lot, Mike.
HIPAA data breaches are emerging as one of the largest systemic risks a hospital or a large group faces in the modern healthcare delivery system. What risk management advice would you give physician clients for maintaining HIPAA confidentiality within their EMR system?